I don't even know if we consider it still an unwritten code that you don't date your ex's friends or your friends' exes. I feel like that's probably actually written down somewhere when it comes to explaining to people how they should behave. And sure, we give high school students a little bit of a pass because their social circles are small. And it's kinda low stakes in most high school relationships anyway. I would offer my younger listeners an apology, but I've seen the statistics and most of you are in your 30s. High school is the time to begin learning who you are and the kind of person you want to date, and if it turns out that you'd rather date that person's friend, I don't know that it has the longest term consequences. But when the world opens up to you, I think we can all agree that your dating pool should too. I guess specialist second-class Douglas Rogan never got that memo. This is Conduct Unbecoming. I'm Erin, and I'm your host. I'm adding a quick opening note that this case does discuss sexual assault and resulted in conviction for attempted sexual assault. The details are perhaps not as disturbing as other cases, but I'm adding this note so that you can make the choices that are right for you with respect to what you listen to and the media you consume. Retail Services Specialist Second-Class Tavian Douglas Rogan served in his role in a city I cannot pronounce in a region that's an equally large linguistic pitfall for me, in Germany. I shan't give myself heartburn trying desperately and failing to say these names. Suffice to say, it's neither Berlin nor Stuttgart. When there's a language and cultural barrier, my observation is that it seems a bit harder for young single service members to date. The local population under those circumstances maybe just isn't interested, or perhaps it's that linguistic and cultural divide. Whatever the reason, military installations overseas seem to become a bit of an exclusive dating service. When Douglas Rogan found himself on the outs with his girlfriend, he didn't have to look far for a new love interest. Specifically, he didn't even look beyond the bounds of her apartment. He set his sights on someone we're going to refer to as logistics specialist seaman Hannah. At some point during the evening, on a date that the opinion doesn't actually specify, Douglas Rogan got hold of Hannah's wallet and swiped her room access key card. He used that to unlock the door to her bedroom while she was sleeping, which I think might mean that Hannah left her wallet in the common area and that Douglas Rogan waited until she was asleep to creep in. Which would also mean that he wasn't so on the outs with his girlfriend. He was there, probably visiting her. So much for the male loneliness epidemic. After creeping into Hannah's room, he sat on the floor and just watched her for hours while she slept. He spent that time thinking about what he would do with her sexually. And I think it bears repeating that Douglas Rogan spent hours sitting on the floor. I naturally picture this as him sitting crisscross applesauce, in case you also needed the mental image. After literal hours deliberating on his next steps, Douglas Rogan stood undressed and crept into Hannah's bed. Hannah awoke to the terrifying reality of Douglas Rogan on top of her, rubbing his erect penis on her leg. She gave him a very slight benefit of the doubt, explaining that he was in the wrong room, saying, "No, I'm Hannah," while trying to clarify for him that she was not his girlfriend. She continued explaining who she was, and Douglas Rogan told her she should just let it be. What a rapey statement. He moved forward as if to kiss her, which prompted her to yell out for her roommate, and to try and push Douglas Rogan off of her. but he used the leverage of his size and position, smashing his hand over her mouth, restraining her arms, and sitting across her stomach, pinning her to the bed. With his free hand, he grabbed Hannah's phone and powered it down, tossing it to the side and out of Hannah's reach. Hannah couldn't flip Douglas Rogan off of her, but she was able to wiggle her face free and began pleading with him to stop. She explained that this would ruin their friendship, and somehow that was enough to convince Douglas Rogan to relent. When the investigative stage was complete, the government charged Douglas Rogan with one specification of attempted sexual assault, for attempting to sexually assault Hannah while he knew she was asleep, and one specification of attempted rape, for attempting to commit a sexual act on Hannah through unlawful force. He filed a motion to dismiss the attempted rape specification as unreasonably multiplied, and the military judge opted to defer the resolution of that motion until after findings. The mixed panel convicted Douglas Rogan of one specification of attempted rape, one specification of attempted sexual assault, and one specification of burglary. Well, the panel also convicted him of one specification of abusive sexual contact, one specification of assault with intent to commit sexual assault, and one specification of wrongful appropriation for taking the key card. But the military judge conditionally dismissed those charges. He merged the specification of attempted sexual assault with attempted rape for the purposes of sentencing. Because Douglas Rogan committed these acts before new rules regarding special offenses went into effect, the sentencing was not a decision from the judge, but rather the panel itself. Douglas Rogan wanted the fact that he would have to register as a sex offender in front of the panel when they decided his fate, and filed a motion to admit that evidence. The judge summarily denied it, but it didn't stop Douglas Rogan from lobbing the information at his panel anyway during his unsworn statement. In that statement, Douglas Rogan advocated for a lighter sentence, stating, "I ask you to consider that even after turning myself in, the consequences of my actions will be there for the rest of my life. Under federal law, I have to register as a sex offender. That law requires that my name, address, face, and conviction will forever be online for the world to see. My life will never be the same. Every job I apply for, they'll know what I've done. Landlords will hesitate to give me a lease. I'll have limitations for housing, employment, education, and will be judged by society forever." I suspect he thought that sex offender registration should be enough of a punishment, and he shouldn't also receive significant prison time. To respond to his unsworn statement, well, yeah, landlords should have every right to refuse a lease to someone who broke into a resident's room and sat there for hours plotting how best to rape her. He should never live in a communal living space like a dorm. He shouldn't be hired into a job where vulnerable people might be similarly assaulted. And I guess I just don't have a lot of sympathy for this sob story because, in contrast, Hannah's life will also never be the same. She'll second-guess the security of her apartment, her room, and her bed, likely for the rest of her life. She wouldn't bear the external social markers that Douglas Rogan was so worried about, but rather the emotional and psychological scars of what he put her through. The judge reminded the panel that their job was to adjudge an appropriate sentence for Douglas Rogan based on the offenses they convicted him for. It was not their job to try and predict the registration requirements in any of the 50 states in which Douglas Rogan might eventually reside, or let those potential collateral consequences influence their decision-making. Consistent with their findings, the panel sentenced Douglas Rogan to confinement for 39 months, a reduction from E5 to E1, and a dishonorable discharge. Instead of jumping straight to the appellate issues, I want to circle back to this unsworn statement. When I first heard about unsworn statements in courts-martial, I thought counsel was pulling my leg. Someone adjudged to be guilty of the crime got to get up and make statements as to what happened without the potential consequence of perjury. They could get up there and lie without repercussions if they so chose. They aren't cross-examined on their statements, and that seemed like a setup that is rife with opportunity for misleading panel members. As you may have guessed, it's not a thing in the civilian world. So I figured today we could talk about the origins of this unique and strange custom that boggles my lawyer brain. My primary source for this information is a law review article by Major Rendleman and is linked in the show notes. Unsworn statements were quietly slipped into military justice in 1951 when President Truman created the unsworn statement for use during the pre-sentencing phase of a court-martial. The move came after decades, if not centuries, of peeling back restrictions on courts-martial and defendants. In the early 19th century, accused service members were not permitted to take the stand as a witness in their own court-martial, and the origin and justification for that rule dated back to a 16th century spiritual kindness the court provided to an accused, removing the temptation to perjure themselves before God, which arguably is a great reason for the continued separation of church and state. In fact, for a long time, defense advocates or attorneys, if they could be spared, were also not permitted to actually speak at a court-martial. Concerns, perhaps those about moral decay and perjury, remained, even as defendants gained more rights. Courts were still hesitant to question defendants under oath, which right now we would probably translate as protecting a defendant's constitutional rights and not compelling a statement from them. But courts were a lot less reticent about questioning defendants in unsworn statements. And judges often gave the accused one final opportunity to speak in his or her defense before the case was submitted to the jury. It was an opportunity for a defendant to directly present his or her case to the jury, like a closing argument, but not. Because a defendant could toss in brand new information. Some courts didn't like that and excluded new facts. Others had no problem with it and let it ride. Against that weird legal landscape, the first instructions for courts-martial came out. An accused could swear in to testify to their defense and be subject to a cross-examination, or an accused could make a verbal statement to the court or submit a written statement to be read aloud for him. And we can appropriately gender the participants as men because the military was all men at that point. The unsworn statement was an accused's final defense. That statement could consist of a brief summary of the evidence, any relevant explanation, and a presentation of the law of the case, which looks like a closing argument and quacks like a closing argument. As attorneys took a greater role in courts-martial, the unsworn statement took a back seat. The accused didn't need to make a closing statement if their counsel could do that for them. And consistent with that fact, in the wake of World War II, the Judge Advocate General of the Navy recommended eliminating the unsworn statement entirely. So that pre-1951 closing argument precursor was eliminated. It was then promptly replaced by unsworn statements in the pre-sentencing hearing. Truman had added this robust description of a pre-sentencing hearing, establishing defense's right to introduce mitigation and extenuation evidence to include affidavits, certificates, and other writings that would otherwise not be admissible due to authentication or hearsay problems. Included in that description was an accused's right to make a statement. That statement shouldn't be evidence and shouldn't include argument, which was for the attorney to figure out. And if something at trial is not evidence and it's not argument, perhaps it's also not necessary. Nevertheless, these new rules rebranded the opportunity for the accused to directly address the court. The Court of Appeals for the Armed Forces has upheld the right of an accused to chat about things that their attorneys wouldn't even be allowed to mention. And recently, the Air Force Court of Criminal Appeals concluded in the United States versus Hamilton that the, quote, not evidence guideline means the unsworn statement isn't subject to the rules of evidence. So it would be kosher for an accused to, for instance, make a statement that could be unfairly prejudicial, confuse the issues, or mislead the panel. I offer all of this not as a thorough explanation of all the historical trends that led to the modern unsworn statement, but as a basic background of my bewilderment. On appeal, Douglas Rogan raised two issues. He argued first that the charged conduct was substantially one transaction, and that charging the conduct separately was an unreasonable multiplication of charges. Second, and tying back to that unsworn statement, he argued that the military judge made the wrong evidentiary decision when they denied Douglas Rogan's motion to admit evidence of anti-recidivism laws that would apply to his conviction, those registration requirements, the stuff he talked about in his unsworn statement instead of introducing as actual evidence. As to the first issue, the Navy and Marine Corps Court of Criminal Appeals concluded that the military judge properly applied the precedent on the issue of unreasonable multiplication of offenses and moved along, turning to the admissibility of the information about sex offender registration as evidence. The guiding precedent on the issue is the United States versus Talkington. There, CAF held that a military judge may provide appropriate context to references to sex offender registration in an unsworn statement. That is, the military judge may inform members that an accused is permitted to reference sex offender registration in their unsworn statement, and can also inform them that those consequences should not influence their deliberations. Defense wanted to go beyond the unsworn statement and introduce actual evidence of sex offender registration requirements. In order to be admissible, of course, evidence has to be relevant. And unless they were going to introduce the requirements in all 50 states alongside the requirements in various territories, I don't know that the specific registration requirements are particularly relevant. From what I gather, Douglas Rogan was from Illinois, but it's not like he was required to move back to Illinois after he got out of custody. At best, evidence of sex offender registration requirements are speculative as to a collateral consequence, and collateral consequences are categorically not appropriately considered for sentencing. So, under a few theories, it wouldn't make sense to allow Douglas Rogan to introduce those details as evidence. Taken together, that was the NMCCA telling Douglas Rogan to pound sand. I do think that this issue is unlikely to continue cropping up, in part because special offenses that happened on or after December 28, 2023, to include offenses that would require sex offender registration, they're no longer sent to a panel for sentencing. There are fewer uninformed, impressionable ears to get that information in front of, because that sort of sentencing is handled only by a military judge. Thank you for listening. If you enjoyed today's episode, please share it. I invite you to submit case suggestions and feedback to conductunbecomingpod@gmail.com or on the website conductunbecomingpod.com. Join me next time when we visit another case of the failed collection of evidence. Until then, take care. Conduct Unbecoming is a podcast where I get to talk about interesting crimes and cases that involve U.S. military service members. I research, write, and produce the podcast myself. The opinions expressed are my own, and perhaps it's obvious. Conduct Unbecoming is not approved, authorized, or endorsed by the Department of Defense, or by their new preferred name, the Department of War.